Hi there. I'm sorry I'm not able to join you in Winnipeg, but I am going to try to speed through my slides in about 15 minutes. This is based on research I did for my LLM. It's about essential services, so I'm talking about social assistance, child welfare, assisted living, policing, emergency services, education, health, all these services provided on reserve. Okay, to tell you a little bit about how the system of services on reserve works, it's divided into three parts. Essentially, the federal government provides funding through funding agreements for delivery of services by First Nations. Also, the federal government essentially holds all of the control, and we'll talk about that a bit more. Second, the rules and the standards for how programs are actually to be provided and their rates are come from provincial rules or territorial rules, and that's through usually the federal government adopting through its policies or funding agreements provincial rules. There's a few situations where provincial rules actually apply, and we'll talk about that in a minute. Finally, when it comes to the actual delivery of services, First Nations actually provide the services within their communities. And we'll talk about how that's done in a moment. So the way that this system came to be is that following World War II, at a time when there was greater emphasis on human rights and the social safety network, a committee of Parliament and the Senate was designated to look at impoverishment in First Nations communities. First Nations for a very long time had been subject to the assimilation policy of residential schools and day schools, and other policies had left them in a situation of significant impoverishment in their communities, and now there was attention being given by Canada. The committee came back with a recommendation, first recognizing that First Nations did not have access to any of the same services provided either by the provinces or the federal government. And their solution to this was to suggest that delivery of services and programs should be given by the provinces. Along with that, there was a notion that the rules in the Indian Act and the reserve system were holding First Nations back, and the solution to their problems would be their absorption into the mainstream and delivery by the provinces of their services. If it sounds familiar, it's the same policy that underlies the 1969 White Paper. Okay, next. So in order to effectuate this policy, the first thing that the federal government tried to do when it amended the Indian Act in 1951 was to include Section 88, which provides that provincial rules of general application can apply on reserve so long as it's not inconsistent with the terms of the Indian Act or treaties. But this did not have the intended effect that was hoped, which was that the federal or that the provincial and territorial governments would assume jurisdiction for services on reserve. Instead, most of the provinces balked at this idea, citing that they thought that Indians were a federal responsibility, and that if they were to assume such responsibility, they would have to be completely reimbursed by the federal government. So the next thing that Canada tried to do was then try to negotiate with the provinces, and in fact amended the Canada Assistance Plan Act to allow for these types of negotiated agreements with the provinces. But in fact, only one province came on board with this type of negotiated agreement, signed in 1965 with the Ontario government, who provides social assistance and a number of other essential services under its legislation. But aside from that, the rest of the provinces were fairly unwilling, except in the case of child welfare legislation, where after the government agreed to reimburse the provinces for apprehensions underneath their provincial legislation, this started to happen. And this was in the mid-60s, and this is where we see the sort of transition from more residential schools to what happened in the 60s scoop, and the significant role that child welfare services now play in our communities. So because fairly few provinces came on board, the federal government instead, it still thought it might succeed, but as a temporary measure, recognizing that the impoverishment and lack of services to First Nations was a real issue, in 1964, Canada received a Treasury Board approval to provide services on reserve, adopting provincial rates and standards as delivery. And that usually is effectuated through INAC and other departments coming up with their own policies that resemble whatever the provincial rules and regulations may be. And the standard has a sort of common name, which is comparability or reasonable comparability, and that's this idea that service delivery will be comparable to what's provided in the provinces and territories. Although it was intended as a temporary measure, it has in fact become the status quo, and it hasn't changed for over 50 years. The other part of this is that after the sort of reaction to the white paper in 1969, and Canada dismissed the white paper and embraced that it would be doing more things with respect to greater self-administration and self-government. In the 70s, the Feds and 80s, the Feds started looking at adapting funding agreements in order to allow First Nations to be able to provide the services within their own community. So this is called program devolution, and yes, it's effectuated through funding agreements in the nature of contribution agreements. So these are agreements where the Feds set out the terms and conditions under which funding will be applied, and if they're not complied with, it allows the government to hold First Nations in default, and there's various remedies, including canceling the agreement or stepping in and assuming control over the financial management of the band, and lesser things as well. But that is generally how these agreements have been structured. There's been some differences between different types of agreements, some that provided a bit more flexibility in how bands use the funds, but overall the main point is that the terms and conditions are completely dictated by the federal government, who exercises a significant amount of control over the services through this. So let me now try to run through what I see as the major problems with this system. Number one, I believe it's premised on assimilation. The idea behind it, getting First Nations to fall under provincial services and be in the provincial mainstream, very much is consistent with the policy of the white paper, which although was discarded by the federal government, nonetheless still underlies this system. Number two is that the system largely leaves First Nations out of policy development and design. As I say, the federal government is responsible ultimately for controlling the system and determining what standards apply, but because it just whole cloth adopts whatever the provincial governments apply, there's really no opportunity in that system for thoughtful deliberation on what policies should exist in First Nations communities based on First Nations needs and circumstances. Nobody is really looking at that, either the provincial government or the feds. And so it's sort of it's a theme that we see over and over again in the history of First Nations relationship with Canada, is that First Nations are often viewed as a sort of hot potato or political football issue. Neither level of government really wanting meaningful responsibility in dealing with First Nations. There's also some other rules that make this whole system a little strange. There's the constitutional rule against singling out, which states that only provincial rules of general application can apply on reserves. And so sometimes people say, well, the solution to this is just for the provinces to exercise their jurisdiction here a bit more humanely and benignly, and maybe craft or accommodate within their laws First Nations needs. But there's also some constitutional rules that suggest that provinces can actually do so. So the whole system's a little strange in that regard. Next, the system, obviously, if it's designed by the provincial government or the rules are, is not culturally appropriate. They're based on Euro-Canadian values such as capitalism, liberalism, and individualism, and really do not reflect First Nations views. These can be views about what the purpose of social assistance is. Often it's geared at, a temporary last resort because no work is available, but that really doesn't take into account the circumstances that exist in First Nations communities. As with child welfare, it doesn't take into account, first of all, the differences in parenting approaches and values and family composition, as well as, First Nations poverty and how that may translate to certain social workers to seem as though because First Nation children are living in abject poverty, that they're being neglected by their parents. So a number of issues there. Number 4, again, coming back to these contribution agreements, many people have pointed out, and as well as the Auditor General, that it really is a fundamentally flawed instrument to really deal with what is a government-to-government or nation-to-nation relationship. These agreements are standard form. First Nations really have very little say in what's in them, and they only really have a choice of either to accept them or not, but they don't really have a choice because often these are for the most essential services provided within the community that people rely on just to live. So First Nations really don't have a choice in what's in these agreements. And there's very little flexibility, as I said before, within them for First Nations to be able to make their programs more culturally appropriate. It also, these agreements impose an inordinate amount of reporting requirements and controls by INAC or other departments over First Nations. I believe the Auditor General in a report in 2006 identified something like 136 reports that administrators within First Nations have to send to INAC about how they're spending program dollars. And that's in addition to all the other work that they need to do, often when they are understaffed and underfunded in order to provide services. Next, the system violates the rule of law. There's nothing in the Indian Act providing for the system, nor is there in any other federal legislation. The only legislation that is applicable is the Department of Indian Affairs Act, which creates the department and their general jurisdiction over Indian affairs. And so what happens is when you have no laws, and here what you have instead are policies, funding agreements, is a heck of a lot of discretion. And where there's discretion, there's possibility of abuse. And there was several cases during the Harper administration where Indigenous groups took the government to court for abuses in power for changes to funding agreements unilaterally, to changing their interpretation from long-held reasonable interpretations to ones that would have caused significant harm. So a ton of discretion. Also, the funding agreements do not provide much by way of dispute resolution mechanisms, and generally there is very little available in terms of access to justice. You can bring an administrative law sort of challenge. Often Section 35 challenges are not successful. Human rights, so the child welfare case and other cases that are ongoing are mechanisms that we can use to challenge this area. But generally, there hasn't been a lot of pushback by First Nations for poverty and other reasons in terms of challenging this system. And the fact that there is no legal system makes it even harder to challenge. Generally, as well, because there's no legislation that gets before Parliament, there's very little accountability or oversight by Parliament of what INAC is doing. And often what we see instead is the Parliament often reacting to situations happening on reserve, like a suicide epidemic or a health problem, as opposed to very thoughtful, deliberative policy design along with First Nations. There's severe funding issues. One of the reports that came out of that came to light during the child welfare case showed that INAC knew that if its social programs were actually administered by the provinces, that they would be paying significantly more. So there's acknowledgement within the department that they're underfunding various programs, and that is exacerbated by the 2% funding cap that's been in place since 1996. And there's all kinds of examples from child welfare to education to social assistance to emergency services. And right now, in addition to the child welfare case, there's a special education case and a policing case that are working their way through the human rights system. So all of these problems have resulted, in fact, in a situation where living conditions have not improved, and I believe that the system is very much a part of that. It's not just the impacts of colonialism, it's that we have a very, very poorly designed system of basic essential services that is making things much worse. And it leads to First Nations continuing to be at the bottom of virtually every socioeconomic indicator in the country. And the little chart here, the gold is First Nations, the blue is other non-Aboriginal Canadians. And what it shows is that for the last 30 years, there's been a significant gap in the well-being index, and that's not closing. The gap just continues to remain the same, despite sort of a general overall increase in standard of living a tiny bit, the gap is still very significant. Other problems with the system, it fuels stereotypes and hate. So the fact is that most people don't understand how programmed evolution works and how the delivery of essential services work. They don't understand that this is money for the same programs and services that other people in the country receive. And instead, many people perceive it as buckets of money being thrown at First Nations issues. And so when sometimes these people continue to hear about poverty and social problems in communities, instead of wondering why or understanding that it's because it's underfunding and a poorly designed system of essential services, instead the blame is placed at the feet of First Nations themselves, in particular their leadership. They're charged with being corrupt or incompetent, and that's really because of a lack of understanding. And sometimes some politicians have capitalized on this system and fueled those stereotypes in some of their policy responses. Lastly, as part of this, the department, especially Indian Affairs, has a significant role in delivering this system. And as part of the problems in that is that there is no legislation, as I mentioned before, but there's no legislative objectives that guide the work that INAC does. And so it really lacks a real focus about what it's supposed to be doing. And some of the research that I did shows that INAC vacillates at times between whether its main objective is really to monitor First Nations adherence to funding terms and program requirements and really policing First Nations versus ensuring First Nations well-being is promoted and advanced, and also assisting First Nations in moving towards self-government. There's a real, at various points in history or recent history, been confusion in that, and very much in the last several years under the Harper regime, the pendulum had really swung to the side of really seeing their role as one as policing and monitoring First Nations funding. Another issue with INAC is that if their real goal, and as I think it should be, is to help First Nations actually move towards self-government, then they're in fact in a clear conflict of interest, because by doing so, they'd be working themselves out of a job. I mean, it might sound funny, but really we do have to question, well, if we expect that we want the INAC to essentially move itself out of the way to allow for greater First Nations control, well, but the fact of having a department that actually continues to be growing is not really achieving that goal. So I'm a little bit over time. There's my presentation. Wish I could be there, and I wish you great panel. Here's a couple additional readings. If you want to read my whole paper, which is about 100 pages long, send me an email, or you can also find me online. Another great paper is by Judith Ray called Program Delivery Devolution, Stepping Stone or Quagmire, and the citation is there. Thank you.